Hello, everyone. Today's case is Ward's Cove Packing Company versus Atonio. This is a disparate impact case, and the gist of it is what went to the Supreme Court was the race statistics of the company may have had a prima facie case about disparate impact. So let's see what the justice said about it. All right. Jobs at petitioners' Alaskan Salmon Canneries are of two general types: unskilled cannery jobs on the cannery lines, which are filled predominantly by non-whites, and non-cannery jobs, most of which are classified as skilled positions and filled predominantly with white workers, and virtually all of which pay more than cannery positions. Respondents, a class of non-white cannery workers at petitioners' facilities, filed suit in the district court under Title VII of the Civil Rights Act of 1964, alleging, inter alia, that various of petitioners' hiring/promotion practices were responsible for the workforce's racial stratification and had denied them employment as non-cannery workers on the basis of race. The district court rejected respondents' claims, finding, among other things, that non-white workers were overrepresented in cannery jobs because many of those jobs were filled under a hiring hall agreement with a predominantly non-white union. The Court of Appeals ultimately reversed, in pertinent part, holding inter alia that respondents had made out a prima facie case of disparate impact in hiring for both skilled and unskilled non-cannery jobs, relying solely on respondent statistics showing a high percentage of non-white workers in cannery jobs and a low percentage of such workers in non-cannery positions. The court also concluded that once a plaintiff class has shown disparate impact caused by specific identifiable employment practices or criteria, the burden shifts to the employer to prove the challenged practice's business necessity. Held. The Court of Appeals erred in ruling that a composition of the percentage of cannery workers who are non-white and a percentage of non-cannery workers who are non-white. Let me start that over. The Court of Appeals erred in ruling that a comparison of the percentage of cannery workers who are non-white and the percentage of non-cannery workers who are non-white makes out a prima facie disparate impact case. Rather, the proper comparison is generally between the racial composition of the at-issue jobs and the racial composition of the qualified population in the relevant labor market. With respect to the skilled non-cannery jobs at issue, the cannery workforce in no way reflected the pool of qualified job applicants or the qualified labor force population. Petitioners' selection methods or employment practices cannot be said to have had a disparate impact on non-whites if the absence of minorities holding such skilled jobs reflects a dearth of qualified non-white applicants for reasons that are not petitioners' fault. With respect to the unskilled non-cannery jobs, as long as there are no barriers or practices deterring qualified non-whites from applying the employer's selection mechanism, probably does not have a disparate impact on minorities if the percentage of selected non-white applicants is not significantly less than the percentage of qualified non-white applicants. Where this is the case, the percentage of non-white workers found in other positions in the employer's labor force is irrelevant to a prima facie statistical disparate impact case. Moreover, isolating the cannery workers as the potential labor force for unskilled non-cannery jobs is both too broad because the majority of cannery workers did not seek non-cannery jobs, and too narrow because there are many qualified persons in the relevant labor market who are not cannery workers. Under the Court of Appeals method of comparison, any employer having a racially imbalanced segment of its workforce could be hauled into court and made to undertake the expensive and time-consuming task of defending the business necessity of its selection methods. For many employers, the only practicable option would be the adoption of racial quotas, which has been rejected by this court and by Congress in drafting Title VII. The Court of Appeals theory is also flawed because if minorities are overrepresented in cannery jobs by virtue of petitioners having contracted with a predominantly non-white union to fill those positions, as the district court found, petitioners could eliminate respondents' prima facie case simply by ceasing to use the union, without making any change whatsoever in their hiring practices for the non-cannery positions at issue. On remand for a determination whether the record will support a prima facie disparate impact case on some basis other than the racial disparity between cannery and non-cannery workers, a mere showing that non-whites are underrepresented in the at-issue jobs in a manner that is acceptable under the standards set forth herein will not alone suffice. Rather, the courts below must also require, as part of respondent's prima facie case, a demonstration that the statistical disparity complained of is the result of one or more of the employment practices respondents are attacking here, specifically showing that each challenged practice has a significantly disparate impact on employment opportunities for whites and non-whites. This specific causation requirement is not unduly burdensome, since liberal discovery rules give plaintiffs broad access to employers' records, and since employers falling within the scope of the Uniform Guidelines on Employee Selection Procedures must maintain records disclosing the impact of tests and selection procedures on employment opportunities of persons by identifiable race, sex, or ethnic group. If, on remand, respondents establish a prima facie disparate impact case with respect to any of petitioner's practices, the burden of producing evidence of a legitimate business justification for those practices will shift to petitioners, but the burden of persuasion will remain with respondents at all times. This rule conforms with the usual method for allocating persuasion and production burdens in the federal courts and with the rule in disparate treatment cases that the plaintiff bears the burden of disproving an employer's assertion that the adverse employment practice was based solely on a legitimate neutral consideration. To the extent that some of this court's decisions speak of an employer's burden of proof with respect to the business justification defense, they should be understood to mean that an employer's burden of production, not persuasion. Even if respondents cannot persuade the trier of fact on the business necessity in question, they may still prevail by coming forward with alternatives that reduce the disparate impact of petitioners' current practices, provided such alternatives are equally effective in achieving petitioners' legitimate employment goals in light of the alternatives' costs and other burdens. Reversed and remanded. Justice White delivered the opinion of the court in which Chief Justice Rehnquist, O'Connor, Scalia, and Kennedy joined. Blackmun filed a dissenting opinion in which Brennan and Marshall joined. Stevens filed a dissenting opinion in which Brennan, Marshall, and Blackmun joined. Justice White delivered the opinion of the court. Title VII of the Civil Rights Act of 1964, as amended, makes it an unfair employment practice for an employer to discriminate against any individual with respect to hiring or the terms and condition of employment because of such individual's race, color, religion, sex, or national origin, or to limit, segregate, or classify his employees in ways that would adversely affect any employee because of the employee's race, color, religion, sex, or national origin. Griggs versus Duke Power Company construed Title VII to proscribe not only overt discrimination, but also practices that are fair in form but discriminatory in practice. Under this basis for liability, which is known as the disparate impact theory and which is involved in this case, a facially neutral employment practice may be deemed violative of Title VII without evidence of the employer's subjective intent to discriminate that is required in a disparate treatment case. The claims before us are disparate impact claims, involving the employment practices of petitioners, two companies that operate salmon canneries in remote and widely separated areas of Alaska. The canneries operate only during the salmon runs in the summer months. They are inoperative and vacant for the rest of the year. In May or June of each year, a few weeks before the salmon runs begin, workers arrive and prepare the equipment and facilities for the canning operation. Most of these workers possess a variety of skills. When salmon runs are about to begin, the workers who will operate the cannery lines arrive, remain as long as there are fish to can, and then depart. The canneries are then closed down, winterized, and left vacant until the next spring. During the off-season, the companies employ only a small number of individuals at their headquarters in Seattle and Astoria, Oregon, plus some employees at the winter shipyard in Seattle. The length and size of salmon runs vary from year to year, and hence the number of employees needed at each cannery also varies. Estimates are made as early in the winter as possible. The necessary employees are hired, and when the time comes, they are transported to the canneries. Salmon must be processed soon after they are caught, and the work during the canning season is therefore intense. For this reason, and because the canneries are located in remote regions, all workers are housed at the canneries and have their meals in company-owned mess halls. Jobs at the canneries are of two general types: cannery jobs on the cannery line, which are unskilled positions, and non-cannery jobs. which fall into a variety of classifications. Most non-cannery jobs are classified as skilled positions. Cannery jobs are filled predominantly by non-whites, Filipinos, and Alaska Natives. The Filipinos are hired through and dispatched by Local 37 of the International Longshoremen's and Warehousemen's Union, pursuant to a hiring hall agreement with the local. The Alaska Natives primarily reside in villages near the remote cannery locations. Non-cannery jobs are filled with predominantly white workers who are hired during the winter months from the company's office in Washington and Oregon. Virtually all of the non-cannery jobs pay more than cannery positions. The predominantly white non-cannery workers and the predominantly non-white cannery employees live in separate dormitories and eat in separate mess halls. In 1974, respondents, a class of non-white cannery workers who were or had been employed at the canneries, brought this Title VII action against petitioners. Respondents alleged that a variety of petitioners' hiring/promotion practices, for example, nepotism, a rehire preference, a lack of objective hiring criteria, separate hiring channels, a practice of not promoting from within, were responsible for the racial stratification of the workforce and had denied them and other non-whites employment as non-cannery workers on the basis of race. Respondents also complained of petitioners' racially segregated housing and dining facilities. All of the respondents' claims were advanced under both the disparate treatment and disparate impact theories of Title VII liability. The district court held a bench trial, after which it entered 172 findings of fact. It then rejected all of respondents' disparate treatment claims. It also rejected the disparate impact challenges involving the subjective employment criteria used by petitioners to fill these non-cannery positions, on the ground that those criteria were not subject to attack under a disparate impact theory. Petitioners' objective employment practices, for example, an English language requirement, alleged nepotism in hiring, failure to post non-cannery openings, the rehire preference, etc., were found to be subject to challenge under the disparate impact theory, but these claims were rejected for failure of proof. Judgment was entered for petitioners. On appeal, a panel of the Ninth Circuit affirmed, but that decision was vacated when the Court of Appeals agreed to hear the case en banc. The en banc hearing was ordered to settle an intra-circuit conflict over the question whether subjective hiring practices could be analyzed under a disparate impact model. The Court of Appeals held, as this court subsequently ruled in Watson versus Fort Worth Bank and Trust, that disparate impact analysis could be applied to subjective hiring practices. The Ninth Circuit also concluded that in such a case, once a plaintiff class has shown disparate impact caused by specific identifiable employment practices or criteria, the burden shifts to the employer to prove the business necessity of the challenged practice. Because the en banc holding on subjective employment practices reversed the district court's contrary ruling, the en banc Court of Appeals remanded the case to a panel for further proceedings. On remand, the panel applied the en banc ruling to the facts of this case. It held that respondents had made out a prima facie case of disparate impact in hiring for both skilled and unskilled non-cannery positions. The panel remanded the case for further proceedings, instructing the district court that it was the employer's burden to prove that any disparate impact caused by its hiring and employment practices was justified by business necessity. Neither the en banc court nor the panel disturbed the district court's rejection of the disparate treatment claims. Petitioners sought review of the Court of Appeals decision in this court, challenging it on several grounds. Because some of the issues raised by the decision below were matters on which the court was evenly divided in Watson v. Fort Worth Bank and Trust, we granted certiorari for the purpose of addressing these disputed questions of the proper application of Title VII's disparate impact theory of liability. In holding that respondents had made out a prima facie case of disparate impact, the Court of Appeals relied solely on respondents' statistics showing a high percentage of non-white workers in the cannery jobs and a low percentage of such workers in the non-cannery positions. Although statistical proof can alone make out a prima facie case, the Court of Appeals ruling here misapprehends our precedents and the purpose of Title VII, and we therefore reverse. There can be no doubt, as there was when a similar mistaken analysis had been undertaken by the courts below in Hazelwood, that the comparison fundamentally misconceived the role of statistics in employment discrimination cases. The proper comparison is between the racial composition of the at-issue jobs and the racial composition of the qualified population in the relevant labor market. It is such a comparison between the racial composition of the qualified persons in the labor market and the persons holding at-issue jobs that generally forms the proper basis for the initial inquiry in a disparate impact case. Alternatively, in cases where such labor market statistics will be difficult, if not impossible, to ascertain, we have recognized that certain other statistics, such as measures indicating the racial composition of otherwise qualified applicants for at-issue jobs, are equally probative for this purpose. It is clear to us that the Court of Appeals' acceptance of the comparison between the racial composition of the cannery workforce and that of the non-cannery workforce as probative of a prima facie case of disparate impact in the selection of the latter group of workers was flawed for several reasons. Most obviously, with respect to the skilled non-cannery jobs at issue here, the cannery workforce in no way reflected the pool of qualified job applicants or the qualified population in the labor force. Measuring alleged discrimination in the selection of accountants, managers, boat captains, electricians, doctors, and engineers, and the long list of other skilled non-cannery positions found to exist by the district court, by comparing the number of non-whites occupying these jobs to the number of non-whites filling cannery worker positions is nonsensical. If the absence of minorities holding such skilled positions is due to a dearth of qualified non-white applicants for reasons that are not petitioners' fault, petitioners' selection methods or employment practices cannot be said to have a disparate impact on non-whites. One example illustrates why this must be so. Respondents' own statistics concerning the non-cannery workforce at one of the canneries at issue here indicate that approximately 17% of the new hires for medical jobs and 15% of the new hires for office worker positions were non-white. If it were the case that less than 15 to 17% of the applicants for these jobs were non-white and that non-whites made up a lower percentage of the relevant qualified labor market, it is hard to see how respondents, without more, would have made out a prima facie case of disparate impact. Yet under the Court of Appeals theory, simply because non-whites comprise 52% of the cannery workers at the cannery in question, respondents would be successful in establishing a prima facie case of racial discrimination under Title VII. Such a result cannot be squared with our cases or with the goal behind the statute. The Court of Appeals theory, at the very least, would mean that any employer who had a segment of his workforce that was, for some reason, racially imbalanced could be hauled into court, and forced to engage in the expensive and time-consuming task of defending the business necessity of the methods used to select the other members of his workforce. The only practicable option for many employers would be to adopt racial quotas, ensuring that no portion of their workforces deviated in racial composition from the other portions thereof. This is a result that Congress expressly rejected in drafting Title VII. The Court of Appeals theory would leave an employer little choice but to engage in a subjective quota system of employment selection. This, of course, is far from the intent of Title VII. The Court of Appeals also erred with respect to the unskilled non-cannery positions. Racial imbalance in one segment of an employer's workforce does not, without more, establish a prima facie case of disparate impact with respect to the selection of workers for the employer's other positions, even where workers for the different positions may have somewhat fungible skills, as is arguably the case for cannery and unskilled non-cannery workers. As long as there are no barriers or practices deterring qualified non-whites from applying for non-cannery positions, if the percentage of selected applicants who are non-white is not significantly less than the percentage of qualified applicants who are non-white, the employer's selection mechanism probably does not operate with a disparate impact on minorities. Where this is the case, the percentage of non-white workers found in other positions in the employer's labor force is irrelevant to the question of a prima facie statistical case of disparate impact. As noted above, a contrary ruling on this point would almost inexorably lead to the use of numerical quotas in the workplace, a result that Congress and this court have rejected repeatedly in the past. Moreover, isolating the cannery workers as the potential labor force for unskilled non-cannery positions is at once too broad and too narrow in its focus. It is too broad because the vast majority of these cannery workers did not seek jobs in unskilled non-cannery positions. There is no showing that many of them would have done so even if none of the arguably deterring practices exist. Thus, the pool of cannery workers cannot be used as a surrogate for the class of qualified job applicants because it contains many persons who have not and would not be non-cannery job applicants. Conversely, if respondents propose to use the cannery workers for comparison purposes because they represent the qualified labor population generally, the group is too narrow because there are obviously many qualified persons in the labor market for non-cannery jobs who are not cannery workers. The peculiar facts of this case further illustrate why a comparison between the percentage of non-white cannery workers and non-white non-cannery workers is an improper basis for making out a claim of disparate impact. Here, the district court found that non-whites were overrepresented among cannery workers because petitioners had contracted with a predominantly non-white union, Local 37, to fill these positions. As a result, if petitioners, for some permissible reason, ceased using Local 37 as its hiring channel for cannery positions, it appears, according to the district court's findings, that the racial stratification between the cannery and non-cannery workers might diminish to statistical insignificance. Under the Court of Appeals approach, therefore, it is possible that with no change whatsoever in their hiring practices for non-cannery workers, the jobs at issue in this lawsuit, petitioners could make respondents' prima facie case of disparate impact disappear. But if there would be no prima facie case of disparate impact in the selection of non-cannery workers absent petitioners' use of Local 37 to hire cannery workers, surely petitioners' reliance on the union to fill the cannery jobs not at issue here and its resulting overrepresentation of non-whites in those positions does not, standing alone, make out a prima facie case of disparate impact. Yet it is precisely such an ironic result that the Court of Appeals reached below. Consequently, we reverse the Court of Appeals ruling that a comparison between the percentage of cannery workers who are non-white and the percentage of non-cannery workers who are non-white makes out a prima facie case of disparate impact. Of course, this leaves unresolved whether the record made in the district court will support a conclusion that a prima facie case of disparate impact has been established on some basis other than the racial disparity between cannery and non-cannery workers. This is an issue that the Court of Appeals or the district court should address in the first instance. Since the statistical disparity relied on by the Court of Appeals did not suffice to make out a prima facie case, any inquiry by us into whether the specific challenged employment practices of petitioners caused that disparity is permitted, as is any inquiry into whether the disparate impact that any employment practice may have had was justified by business considerations. Because we remand for further proceedings, however, on whether a prima facie case of disparate impact has been made in defensible fashion in this case, we address two other challenges petitioners have made to the decision of the Court of Appeals. First is the question of causation in a disparate impact case. The law in this respect was correctly stated by Justice O'Connor's opinion last term in Watson versus Fort Worth Bank and Trust. We note that the plaintiff's burden in establishing a prima facie case goes beyond the need to show that there are statistical disparities in the employer's workforce. The plaintiff must begin by identifying the specific employment practice that is challenged, especially in cases where an employer combines subjective criteria with the use of more rigid standardized rules or tests. The plaintiff is, in our review, responsible for isolating and identifying the specific employment practices that are allegedly responsible for any observed statistical disparities. Indeed, even in the Court of Appeals, whose decision petitioners assault on this score, noted that it is essential that the practices identified by the cannery workers be linked causally with the demonstrated adverse impact. Notwithstanding the Court of Appeals' apparent adherence to the proper inquiry, petitioners contend that court erred by permitting respondents to make out their case by offering only one set of cumulative comparative statistics as evidence of the disparate impact of each and all of petitioners' hiring practices. Our disparate impact cases have always focused on the impact of particular hiring practices on employment opportunities for minorities. Just as an employer cannot escape liability under Title VII by demonstrating that at the bottom line his workforce is racially balanced, where particular hiring practices may operate to deprive minorities of employment opportunities, a Title VII plaintiff does not make out a case of disparate impact simply by showing that at the bottom line there is racial imbalance in the workforce. As a general matter, a plaintiff must demonstrate that it is the application of a specific or particular employment practice that has created the disparate impact under attack. Such a showing is is an integral part of the plaintiff's prima facie case in a disparate impact suit under Title VII. Here, respondents have alleged that several objective employment practices, for example, nepotism, separate hiring channels, rehire preferences, as well as the use of subjective decision-making to select non-cannery workers, have had a disparate impact on non-whites. Respondents base this claim on statistics that allegedly show a disproportionately low percentage of non-whites in the at-issue positions. However, even if on remand, respondents can show that non-whites are underrepresented in the at-issue jobs in a manner that is acceptable under the standards set forth in Part 2, this alone will not suffice to make out a prima facie case of disparate impact. Respondents will also have to demonstrate that the disparity they complain of is the result of one or more of the employment practices that they are attacking here, specifically showing that each challenged practice has a significantly disparate impact on employment opportunities for whites and non-whites. To hold otherwise would result in employers being potentially liable for the myriad of innocent causes that may lead to statistical imbalances in the composition of their workforces. Some will complain that this specific causation requirement is unduly burdensome on Title VII plaintiffs, but liberal civil discovery rules give plaintiffs broad access to employers' records in an effort to document their claims. Also, employers falling within the scope of the Uniform Guidelines on Employee Selection Procedures are required to maintain records or other information which will disclose the impact which its tests and other selection procedures have upon employment opportunities of persons by identifiable race, sex, or ethnic groups. This includes records concerning the individual components of the selection process, where there is a significant disparity in the selection rates of whites and non-whites. Plaintiffs, as a general matter, will have the benefit of these tools to meet their burden of showing a causal link between challenged employment practices and racial imbalances in the workforce. Respondents presumably took full advantage of these opportunities to build their case before the trial in the district court was held. Consequently, on remand, the courts below are instructed to require, as part of respondents' prima facie case, a demonstration that specific elements of the petitioner's hiring process have a significantly disparate impact on non-whites. If on remand, respondents meet the proof burdens outlined above, and establish a prima facie case of disparate impact with respect to any of petitioner's employment practices, the case will shift to any business justification petitioners offer for their use of these practices. This phase of the disparate impact case contains two components. First, a consideration of the justifications an employer offers for his use of these practices, and second, the availability of alternative practices to achieve the same business ends with less racial impact. We consider these two components in turn. Though we have phrased the query differently in different cases, it is generally well established that at the justification stage of such a disparate impact case, the dispositive issue is whether a challenged practice serves in a significant way to the legitimate employment goals of the employer. The touchstone of this inquiry is a reasoned review of the employer's justification for his use of the challenged practice. A mere insubstantial justification in this regard will not suffice, because such a low standard of review would permit discrimination to be practiced through the use of spurious, seemingly neutral employment practices. At the same time, though, there is no requirement that the challenged practice be essential or indispensable to the employer's business for it to pass muster. This degree of scrutiny would be almost impossible for most employers to meet, and would result in a host of evils we have identified above. In this phase, the employer carries the burden of producing evidence of a business justification for his employment practice. The burden of persuasion, however, remains with the disparate impact plaintiff. To the extent that the Ninth Circuit held otherwise in its en banc decision in this case, or in the panel's decision on remand, suggesting that the persuasion burden should shift to petitioners once respondents establish a prima facie case of disparate impact, its decisions were erroneous. The ultimate burden of proving that discrimination against a protected group has been caused by a specific employment practice remains with the plaintiff at all times. This rule conforms with the usual method of allocating persuasion and production burdens in the federal courts, and more specifically, it conforms to the rule in disparate treatment cases that the plaintiff bears the burden of disproving an employer's assertion that the adverse employment action or practice was based solely on a legitimate neutral consideration. We acknowledge that some of our earlier decisions can be read as suggesting otherwise. But to the extent that those cases speak of an employer's burden of proof with respect to a legitimate business justification defense, they should have been understood to mean an employer's production, not by persuasion, burden. The persuasion burden here must remain with the plaintiff, for it is he who must prove that it was because of such individual's race, color, etc., that he was denied a desired employment opportunity. Finally, if on remand the case reaches this point and respondents cannot persuade the trier of fact on the question of petitioner's business necessity defense, respondents may still be able to prevail. To do so, respondents will have to persuade the fact finder that other tests or selective devices without a similarly undesirable racial effect would also serve the employer's legitimate hiring interests. By so demonstrating, respondents would prove that petitioners were using their tests merely as a pretext for discrimination. If respondents, having established a prima facie case, come forward with alternatives to petitioners' hiring practices that reduce the racially disparate impact of practices currently being used, and petitioners refuse to adopt these alternatives, such refusal would belie a claim that by petitioners that their incumbent practices are being employed for non-discriminatory reasons. Of course, any alternative practices which respondents offer up in this respect must be equally effective as petitioners' chosen hiring procedures in achieving petitioners' legitimate employment goals. Moreover, factors such as the cost of other burdens of proposed alternative selection devices are relevant in determining whether they would be equally as effective as the challenged practice in serving the employer's legitimate business goals. Courts are generally less competent than employers to restructure business practices. Consequently, the judiciary should proceed with care before mandating that an employer must adopt a plaintiff's alternative selection or hiring practice in response to a Title VII suit. For the reasons given above, the judgment of the Court of Appeals is reversed and the case is remanded for further proceedings consistent with this opinion. It is so ordered. Justice Blackmun, with whom Justice Brennan and Justice Marshall joined dissenting, I fully concur with Justice Stevens' analysis of this case. Today, a bare majority of the court takes three major strides backwards in the battle against race discrimination. It reaches out to make last term's plurality opinion in Watson v. Fort Worth Bank and Trust the law, thereby upsetting the long-standing distribution of burdens of proof in Title VII disparate impact cases. It bars the use of internal workforce comparisons in the making of a prima facie case of discrimination, even where the structure of the industry in question renders any other statistical comparison meaningless. And it requires practice-by-practice statistical proof of causation, even where, as here, such proof would be impossible. The harshness of these results is well demonstrated by the facts of this case. The salmon industry, as described by this record, takes us back to a kind of overt and institutionalized discrimination we have not dealt with in years. A total residential and work environment organized on principles of racial stratification and segregation, which, as Justice Stevens points out, resembles a plantation economy. This industry long has been characterized by a taste for discrimination of the old-fashioned sort, a preference of hiring non-whites to fill its lowest-level positions on the condition that they stay there. The majority's legal rulings essentially immunize these practices from attack under a Title VII disparate impact analysis. Sadly, this comes as no surprise. One wonders whether the majority still believes that race discrimination, or more accurately, race discrimination against non-whites, is a problem in our society, or even remembers that it ever was. Justice Stevens, with whom Justice Brennan, Justice Marshall, and Justice Blackmun joined dissenting. Fully 18 years ago, this court unanimously held that Title VII of the Civil Rights Act of 1964 prohibits employment practices that have discriminatory effects as well as those that are intended to discriminate. Federal courts and agencies consistently have enforced that interpretation, thus promoting our national goal of eliminating barriers that define economic opportunity not by aptitude and ability, but by race, color, national origin, and other traits that are easily identified but utterly irrelevant to one's qualification for a particular job. Regrettably, the court treats from these efforts in its review of an interlocutory judgment respecting the peculiar facts of this lawsuit. Turning a blind eye to the meaning and purpose of Title VII, the majority's opinion perfunctorily rejects a long-standing rule of law and underestimates the probative value of evidence of a racially stratified workforce. I cannot join this latest sojourn into judicial activism. I would have thought it superfluous to recount at this late date the development of our Title VII jurisprudence, but the majority's facial treatment of settled law necessitates such a primer. This court initially considered the meaning of Title VII in Griggs v. Duke Power, in which a class of utility company employees challenged the conditions of entry into higher paying jobs upon a high school education or passage of 2 written tests. Despite evidence that these 2 requirements operated to render ineligible a markedly disproportionate number of African Americans, the Court of Appeals had held that because there was no showing of an intent to discriminate on account of race, there was no Title VII discrimination. Chief Justice Berger's landmark opinion established that an employer may violate the statute even when acting in complete good faith without any invidious intent. Focusing on subsection 703A2, he explained, "The objective of Congress is the enactment of Title VII is plain from the language of the statute. It was to achieve equality of employment opportunities and remove barriers that have operated in the past to favor an identifiable group of white employees over other employees. Under the Act, practices, procedures, or tests neutral on their face and even neutral in terms of intent cannot be maintained if they operate to freeze the status quo of prior discriminatory employment practices. The opinion in Griggs made it clear that a neutral practice that operates to exclude minorities is nevertheless lawful if it serves a valid business purpose. The touchstone is business necessity," the court stressed. Because Congress directed the thrust of the Act to the consequences of employment practices, not simply the motivation, Congress has placed on the employer the burden of showing that any given requirement must have a manifest relationship to the employment in question. Congress has declined to act as the court now sees fit to limit the reach of this disparate impact theory. Indeed, it has extended its application. This approval lends added force to the Griggs holding. The Griggs framework, with its focus on ostensibly neutral qualifications standards, proved inapposite for analyzing an individual employee's claim, brought under subsection 703A1, that an employer intentionally discriminated on account of race. The meaning for determining intent absent direct evidence was outlined in McDonnell Douglas Corporation v. Green and Texas Department of Community Affairs v. Burdine, 2 opinions written by Justice Powell for unanimous courts. In such a disparate treatment case, the plaintiff's initial burden, which is not onerous, is to establish a prima facie case of racial discrimination, that is, to create a presumption of unlawful discrimination by eliminating the most common non-discriminatory reasons for the plaintiff's rejection. The burden then must shift to the employer to articulate some legitimate non-discriminatory reason for the employee's rejection. Finally, because Title VII does not permit the employer to use the employee's conduct as a pretext for the sort of discrimination prohibited by subsection 703A1, the employee must be given a full and fair opportunity to demonstrate by competent evidence and that the presumptively valid reasons for his rejection were in fact a cover-up for a racially discriminatory decision. While the burdens of producing evidence thus shift, the ultimate burden of persuading the trier of fact that the defendant intentionally discriminated against the plaintiff remains at all times with the plaintiff. Decisions of this court and other federal courts repeatedly have recognized that while the employer's burden in a disparate treatment case is simply one of coming forward with evidence of legitimate business purpose, its burden in a disparate impact case is proof of an affirmative defense of business necessity. Although the majority's opinion blurs that distinction, thoughtful reflection on common law pleading principles clarifies the fundamental differences between the 2 types of burdens of proof. In the ordinary civil trial, the plaintiff bears the burden of persuading the trier of fact that the defendant has harmed her. The defendant may undercut plaintiff's effort by both by confronting plaintiff's evidence during her case in chief and by submitting countervailing evidence during its own case. But if the plaintiff proves the existence of the harmful act, the defendant can escape liability only by persuading the fact finder that the act was justified or excusable. The plaintiff in turn may try to refute this affirmative defense, although the burdens of producing evidence regarding the existence of harm or excuse thus shift between the plaintiff and the defendant. The burden of proving either proposition remains throughout on the party asserting it. In a disparate treatment case, there is no discrimination within the meaning of Title VII unless the employer intentionally treated the employees unfairly because of race. Therefore, the employee retains the burden of proving the existence of intent at all times. If there is direct evidence of intent, the employee may have little difficulty in persuading the fact finder that discrimination has occurred. but in the likelier event that intent has to be established by inference, the employee may resort to the McDonald-Burdine inquiry. In either instance, the employer may undermine the employee's evidence but has no independent burden of persuasion. In contrast, intent plays no role in the disparate impact inquiry. The question, rather, is whether an employment practice has a significant adverse effect on an identifiable class of workers, regardless of the cause or motive for the practice. The employer may attempt to contradict the factual basis for this effect, that is, to prevent the employee from establishing a prima facie case, but when an employer is faced with sufficient proof of disparate impact, its only recourse is to justify the practice by explaining why it is necessary to the operation of business. Such a justification is a classic example of an affirmative defense. Failing to explore the interplay between these distinct orders of proof, the court announces that our frequent statements that the employer shoulders the burden of proof respecting business necessity should have been understood to mean an employer's production, but not persuasion, burden. Our opinions always have emphasized that in a disparate impact case, the employer's burden is weighty. The touchstone, the court said in Griggs, is business necessity. Later, we held that prison administrators had failed to rebut the prima facie case of discrimination by showing that the height and weight requirements are essential to effective job performance. I am thus astonished to read that the touchstone of this inquiry is a reasoned review of the employer's justification for his use of the challenged practice. There is no requirement that the challenged practice be essential. This casual, almost summary rejection of the statutory construction that developed in the wake of Griggs is most disturbing. I have always believed that the Griggs opinion correctly reflected the intent of the Congress that enacted Title VII. Even if I were not so persuaded, I could not join a rejection of a consistent interpretation of a federal statute. Congress frequently revisits this statutory scheme and can readily correct our mistakes if we misread its meaning. Also troubling is the court's apparent redefinition of the employee's burden of proof in a disparate impact case. No prima facie case will be made, it declares, unless the employees isolate and identify the specific employment practices that are allegedly responsible for any observed statistical disparities. This additional proof requirement is unwarranted. It is elementary that a plaintiff cannot recover upon proof of injury alone. Rather, the plaintiff must connect the injury to an act of the defendant in order to establish prima facie that the defendant is liable. Although the causal link must have substance, the act need not constitute the sole primary cause of the harm. Thus, in a disparate impact case, proof of numerous questionable employment practices ought to fortify an employee's assertion that the practices caused racial disparities. Ordinary principles of fairness require that Title VII actions be tried like any lawsuit. The changes the majority makes today, tipping the scales in favor of employers, are not faithful to those principles. Petitioners seek reversal of the Court of Appeals and dismissal of this suit on the ground that respondents' statistical evidence failed to prove a prima facie case of discrimination. The district court concluded there were significant disparities between the racial composition of the cannery workers and the non-cannery workers, but it made no precise numerical finding on this and other critical points. Given this dearth of findings and the court's newly articulated preference for individualized proof of causation, it would be manifestly unfair to consider respondents' evidence in the aggregate and deem it insufficient. Thus, the court properly rejects petitioners' request for a final judgment and remands for further determination of the strength of respondents' prima facie case. Even at this juncture, however, I believe that respondents' evidence deserves greater credit than the majority allows. Statistical evidence of discrimination should compare the racial composition of employees in disputed jobs to that of the qualified population in the relevant labor market. That statement leaves open the definition of the qualified population and the relevant labor market. Our previous opinions demonstrate that in reviewing statistical evidence, a court should not strive for numerical exactitude at the expense of the needs of the particular case. The district court's findings of fact depict a unique industry. Cannery workers are located in remote, sparsely populated areas of Alaska. Most jobs are seasonal, with the season's length and the cannery's personnel needs varying not just year to year, but day to day. To fill their employment requirements, petitioners must recruit and transport many cannery workers and non-cannery workers from states in the Pacific Northwest. Most cannery workers came from a union local based outside Alaska or from native villages near the canneries. Employees in the non-cannery positions, the positions that are at issue, learn of openings by word of mouth. The jobs seldom are posted or advertised, and there is no promotion to non-cannery jobs from within the cannery workers' ranks. In general, the district court found the at-issue jobs to require skills ranging from English literacy, typing, and the ability to use seam micrometers, gauges, and mechanics hand tools to good health and a driver's license. All cannery workers' jobs, like a handful of at-issue positions, are unskilled, and the court found that the intensity of the work during canning season precluded on-the-job training for skilled non-cannery positions. It made no findings regarding the extent to which the cannery workers already are qualified for at-issue jobs. Individual plaintiffs testified persuasively that they were fully qualified for such jobs, but the court neither credited nor discredited this testimony. Although there are no findings concerning wage differentials, the parties seem to agree that wages for cannery workers are lower than those for non-cannery workers, skilled or unskilled. The district court found that nearly all cannery workers are non-white, while the percentage of non-whites employed in the entire Alaska salmon canning industry has stabilized at about 47% to 50%. The precise stratification of the workforce is not described in the findings, but the parties seem to agree that the non-cannery jobs are predominantly held by whites. Petitioners contend that the relevant labor market in this case is the general population of the external labor market for the jobs at issue. While they would rely on the district court's findings in this regard, those findings are ambiguous. At one point, the district court specifies Alaska, the Pacific Northwest, and California as the geographical region from which petitioners draw their employees, but its next finding refers to this relevant geographical area for cannery worker, laborer, and other non-skilled jobs. But its next finding refers to this relevant geographical area for cannery worker, laborer, and other non-skilled jobs. There is no express finding of the relevant labor market for non-cannery jobs. Even assuming that the district court properly defined the relevant geographical area, it's apparent assumption that the population in that area constituted the available labor supply is not adequately founded. An undisputed requirement for employment, either as a cannery or non-cannery worker, is availability for seasonal employment in the far reaches of Alaska. Many non-cannery workers, furthermore, must be available for pre-season work. Yet the record does not identify the portion of general population in Alaska, California, and the Pacific Northwest that would accept this type of employment. This deficiency respecting a crucial job qualification diminishes the usefulness of petitioner statistical evidence. In contrast, respondents' evidence comparing racial composition within the workforce identifies a pool of workers willing to work during the relevant times and familiar with the workings of the industry. Surely this is more probative than the untailored general population statistics on which petitioners focus. Evidence that virtually all the employees in the major categories of at-issue jobs were white, whereas about two-thirds of the cannery workers were non-white. Many may not by itself suffice to establish a prima facie case of discrimination, but such evidence of racial stratification puts the specific employment practices challenged by respondents into perspective. Petitioners recruit employees for at-issue jobs from outside the workforce rather than from lower-paying, overwhelmingly non-white cannery worker positions. Information about availability of at-issue positions is conducted by word of mouth. Therefore, the maintenance of housing and mess halls that separate the largely white non-cannery workforce from the cannery workers, coupled with the tendency toward nepotistic hiring, are obvious barriers to employment opportunities for non-whites. Putting to one side the issue of business justifications, it would be quite wrong to conclude that these practices have no discriminatory consequence. Thus, I agree with the Court of Appeals that when the district court makes the additional findings prescribed today, it should treat the evidence of racial stratification in the workforce as a significant element of respondents' prima facie case. The majority's opinion begins with recognition that the settled rule that a facially neutral employment practice may be deemed violative of Title VII without evidence of the employer's subjective intent to discriminate that is required in a disparate treatment case. It then departs from the body of law engendered by this disparate impact theory, reformulating the order of proof and the weight of the parties' burdens, Why the court undertakes these unwise changes in elementary and eminently fair rules is a mystery to me. I respectfully dissent. Well, that was a good read. And as always, if there's any case you'd like me to read, just drop it in the comments and I'd be happy to take a look. Thank you.